to impede the justice set by the way it's being here.
Actually, Jeff, if you mind me this letter.
And so he knows I didn't show them to the prosecutor, he has a copy before.
Please rise.
Sit, please. Okay, this is
Case number 21 CR 112, State of Ohio versus Sean Ryan Van Ness. Heard for the state, King, you are Sean Ryan Van Ness.
Yes.
All right, Mr. Van Ness is under plea of guilty to aggravated particular assault, a third-degree felony. However, for sentencing until the death. I have a victim impact statement from Victim Cole, and also the recovery registration. It depends on whether you guys here, but also reflect on prosecuted also.
There should also be a big impact of non-probation.
He's not a victim. There's only one victim in count one, that's Denzel.
He was driving the vehicle.
He's not a victim.
Okay, we just wanted to make the court aware.
I'm aware. All right, anything from the state regarding sentencing?
Your Honor, the state would ask that the court follow the recommendation. We'll note that for the terms of the plea agreement, the defendant has agreed to make full restitution. The problem is, due to the complex nature of all the various bills, as we stand here today, we do not know what the amount of restitution actually is. And I really don't know how to handle that going forward. Taylor Cole is president of the courtroom today and would like to make a statement. That's all I have, Your Honor.
All right, Sloan. I have reviewed your victim impact statement. Speak, please.
I just have to say that I was not the only one that was impacted by the accident. My family also has to look at everything that my mom has to take care of every single day. Get me up out of bed, dress, eat, a bath every day. Take control of my bowels on my own. It's well for me. My boyfriend, and we've been together for 5 years. I'll never be able to walk down the aisle and get married. I'll never be able to have kids and a family of our own. I'll never be able to go outside and pet my dog anymore. I can't pet my dog anymore. There's a whole list of things that it's not doing anymore. God, you begin to tell you, it's just more than just my arms and my legs that I can't do anymore. There's so many things that I was going to do in this life that I no longer do anymore.
And I just hope that somebody can know what I have to say, what the punishment is, and punishment never find whatsoever. That's all I have.
Thank you. Anything else to say?
I'll ask because, you know, the request, the driver of the vehicle, Rodney Gross, is present, and would like to make a statement on what we're permitted at.
Well, I have statements from the defense, man, so I'll allow them to.
Prior to the wreck, I was under the impression that OBI would ruin everything. You lose your license, go to jail, have a big fine to pay. And so, after the wreck, I come to realize that that is not only the case. It appears that you can have multiple OBIs and still legally drive. Even after what Sean has done, both me and Taylor, he is still able to walk to his car, turn the key, and drive down the road. Just as he never did anything. Meanwhile, Taylor is sentenced to life in remorse for the rest of her life. I can't bear a child. Sean could be incarcerated for 3 years, get out, and continue to make bad decisions. That will heavily impact other people's lives.
Thank you. Anything further?
Thank you, Judge. We're asking the court to impose the agreed sentence of 3 years for several reasons. And I want to make clear, nothing I say in mitigation, I don't mean any offense to the questioning of decision.
Stand up and address the court, please.
By any means, but I just wanted to give you a little bit more information about Sean and what you have on the charge. Sean grew up locally on a farm with his family with both parents. He has an older sister too. She has 5 children. She's one of the individuals that addressed the court and has expressed to me that Sean is a loving uncle, helps teach them things living on the farm. After high school and graduated, he attended Hopkins College where he studied wildlife management. That's been very useful to his family, especially on the farm since his father is partially disabled. He's been very helpful to him as that's their only source of income right now. Since Sean's last incident with the justice system, he has started his own business, Your Honor. He worked his way up working small jobs to save enough money to buy a dump truck and bobcat so they can continue that business. He has been saving money since the very first day that we talked about this to make sure that while this means goes towards nothing to make the victim whole by any means, he is fully prepared to pay restitution and wants to do so to her. I'll just submit in terms of character evidence as the letters that were provided by his family. I'd ask the court to take note that since he's been supervised by this court on pretrial, pre-release supervision, he has been compliant. He was drug tested and had no positive violations that I was made aware of. Your Honor, he does, and it's been inappropriate to reach out until this point, but he does want to apologize to the victim and has something to say today if you would allow him to. We're asking to impose the agreed sentence as I mentioned. He had no intention of hurting her, but he made a horrible decision that day. He is here pleading guilty to take responsibility for the harm that he caused her. Nothing really that we can say today in mitigation will come close to making the victim whole by any means. But I do want her and the state to know that Sean has been extremely remorseful and will have to live with what he did to her. That's all I have, Your Honor. Thank you.
And yes, anything you'd like to say?
Yes, Your Honor. Never been more sorry about it in my entire life. Anything that I get sentenced today is not very looking like that door. I just want to know people. I want to hope that
that Miss Taylor, or Miss Cole, is going through, and will do the rest of her life, is just, horrible. And it begin to understand just how difficult it is to be other than know what will be, based on what I've seen in applications over the years. And, of course, nothing the court can do to take that or compensate her for that. One of the problems out here, say it's a terrible mistake, and the kind of history of doing that, I want to say a study of hockey. I also noticed that some of your criminal accident, most of it, drug convictions. I guess it was not received as stolen property. But then in this court, in 2018, they used for trafficking in marijuana. In this situation, we chose to drive or repair the tester's office for 1.154, almost double the limit. Put away. Went left to center and hit these two individuals, causing horrible injuries in their lifelong. And quite honestly, in my opinion, the law's not tough enough. Either shot her with a gun, we got 8 years plus 3 months of that, but since she used a vehicle to cause injuries, albeit not intentional. Once assault, carrying 8 years plus possible 4. 5 years is the limit on this. The parties are stipulated to a 3-year recommendation. Quite honestly, I had trouble seeing any needed value of what was said. But you have second responsibility for the felony conviction. The additional OBI conviction would have been misdemeanor since it would have been one, since it was alternate counts. So it would have been merged, like you're convicted to, would have been something else, 1 year, a 6-month maximum. And so you have second responsibility for that. And so that avoided this whole gross and the family that have to sit through a trial and see your question. So I guess that's a very, very small amount of redeeming value. As far as your letters from your family is concerned, I understand. The problem is that when defendants commit crimes, they also inflict punishment on their families. And so, you've done that completely. You haven't changed all that much, in my judgment. Less than 3 years since you got finished up your sentence on the trafficking charge. And you've had pretty steadily since 08. So, I hope this is your last time you come in front of the court, Donnie. But if I were asked to make it bad, I would make against it. But perhaps this will have some effect. So it's a judgment of the court that you be and are hereby sentenced to a mandatory term of 3 years, 36 months, I should say, since it's a high tier, to the Pretrial Reception Center in order to find and according to the sheriff, you have just 1 day for the office of letter. Now, there won't be any judicial release on this. You will serve it all. And upon completion of that sentence, the law provides that the parole board could, at their option, place you under post-release control for a period of up to 2 years. Yeah, it is 2 years. Yeah, 2 years. Because even though this is a horrible injury, it's not considered a felony violence. And so what that means, if they decide to do it, should be supervised by a parole officer in the terms that they said the court has nothing to do. But if they do it, and you do violate those conditions, they can return you to prison and make you serve an additional period of 9 months for any one violation. There's a half of your prison term, which in this case would be 18 months, or more than one violation. However, if you commit a new felony on post-release control, Then in addition, whatever sentence the judge in new case imposed, that judge would also sentence you for committing that violation while under post-release control in this case to an additional period of 1 year, whatever time is left on the post-release control period, whichever is greater. If that occurs, that would be served consecutively as a sentence in the case. It's also ordered that your license be suspended for a period of 10 years, beginning today. Order to pay the court costs, the judge will grant execution order. And if you fail to do that and make payment arrangements, then the clerk will collect that through various means, including letting the bank accounts, wage earnings, or assets you may have. If that doesn't collect it, then upon completion of your prison term, not liable, but upon completion of that term, you could, in order to keep your service in this county, give you credit for each hour you work, in or out of a set by the court. Each hour you work will reduce your judge by that amount until paid in full. And regarding the restitution, the court has no ability to make a determination on the stand problem in these kind of cases of catastrophic injuries. I don't know if there's any insurance involved or whatever, but obviously there would need to be some determination in a civil proceeding as to what the restitution would be. So I will reserve that subject to future order if there is an award that would be proposed either through a settlement agreement or through a judgment in court or insurance proceeds or something like that. So there's nothing else I can do with that. All right, is there anything further from council? Your name, that's it right now.
Stand up.
Alyssa wants to know what the difference is on that column versus why is there a new page. I said, I don't know, I saw